hopefully that is to protect us.
Thank you. Are there any more public comments?
Peter Warfield, Library Users Association. I'm stunned that in the middle of this discussion, you state 2 minutes. Sunshine Ordinance Section 67.15, Public Testimony Section C says, each policy body shall adopt a rule providing that each person wishing to speak on an item before the body at a regular or special meeting shall be permitted to be heard once for up to 3 minutes, period. There is a lot going on here that is invisible and not noted. So let's just start out with the simple facts. You haven't met for many months. There's no explanation whatsoever on this agenda or any place else as to what's been going on, why you're now meeting, or anything else. That's significant for the record. It should be provided for the record very clearly. Second, there's no clarity at all with respect to what you're going to do regarding pending matters. So, for example, I got an order of determination in April. The letter was prepared in May. I didn't get anything for about a month, so I called the administrator. Oh, I guess it didn't go out. A month after that letter was prepared, it did go out to Supervisor Campos. It had an order of determination saying that the unredacted records had to be provided in 5 days. So 23 days later, I got something. It wasn't the unredacted requested records. It turned out a smaller pile of unredacted records, which very peremptorily, the aide told me if I didn't like it, I could file a complaint. It turned out, supposedly, orally, these were records that previously had been redacted, so they were only giving me those records and not the full group. What's going to happen with the normal appropriate follow-up? That needs to be told, not just to me, but to everybody publicly.
Thank you.
Hello, members. My name is Doug Comstock. I'm a little appalled by the 2-minute rule for general public testimony. After not meeting for 5 months to only allow the public to speak for 2 minutes, and this is the body in this city that is here to protect the public's rights to free speech. This is all we have. But for you to do that, it just seems to me to be disrespectful of the public. Now, I know that 67.15 says for up to 3 minutes. It doesn't say shall be 3 minutes. However, this body, in its amendments, has taken the position that that should be changed to 3 minutes for public testimony, unless there's an inordinate amount of people and it's justified by the number of people who are lined up here to speak, going out the block. Then you have a right to change that from 3 minutes to 2 minutes, let's say. But for you just to do it offhand, and I find this a problem in a lot of bodies in the city, that they just say 2 minutes and the public accepts it, and the members just sit here and say, oh, well, that's fine with me. Well, that's maybe fine with you because it's inconvenient for you to sit here and listen to the public, but it's not convenient for the public, and that's really what you're here for. And the other problem that I have, and I'm sorry we don't have much time to go into it, but I would like to know what you're going to do about cases that come to you concerning the Board of Supervisors. Since you are appointed by the Board of Supervisors, how are you going to hear cases where there's that conflict of interest? I mean, many of you new faces are here because of that very situation. You were appointed because this body took a stand against sitting members of the Board of Supervisors. So I'd like to know, what's the rule that the public can count on? Thank you.
Thank you. Does anyone more public comment?
Good evening, Bruce Wolf, now a general citizen. Welcome back, everybody, and welcome to the Sunshine Ordinance Task Force. As you've heard and have been hearing, this is a really important body. Hasn't met in 6 months. There have been lots of issues that needed to come forward that haven't been heard in public forum. And as the previous speaker had intimated, there is a concern about how and why you're here and what happens when those kinds of decisions come around. Now, we all know that the reason why that we've all been replaced was because of the Park Merced decision and how that went down. So what happens if a like kind of situation comes back? What will you do? You already have pretty much case law. You have precedent set on that particular item and how that decision was made. So I urge you to think about that as you move forward and to stay strong in your integrity, in your personal integrity, and not with your political integrity, because we know that's how this all came down. That is all a matter of politics. So I also would urge you that if you haven't, to please start reading Code 67 and really be conscious of when those things come up, because it's gonna, during a hearing, you're gonna hear a lot of things and something may ring a bell for you. And if you weren't familiar with the ordinance, it may not, you'll miss it. So it's important, and even if it's just to ask a question, that's really the importance of being knowledgeable about it. So thank you, that's all I have to say right now. Thank you.
Thank you. Is there any more public comment? If not, I just want to say one thing for the record regarding the 2 minutes. I know that it's up to 3 minutes. We have been so backlogged and we've yet to get to any of these complaints that are here. So for the time being, until we get to a lot of these cases, that's why I instituted the 2 minutes. As our caseload lessens, I will go back to the 3-minute rule, because I totally agree with what you guys are saying. But we come to these meetings, we have yet to get to one case, which is what we are here to do. So I'm going to do that. The next item is item number 6. Madam Clerk, would you read that for me, please?
Item number 6, Sunshine Ordinance Task Force bylaws.
So there